All right, Ms. Van Duzen, let me bring Mr. Rembert back. All right. Mr. Rembert. All right. All right, Ms. Van Duzen. She stepped away from Mr. Rembert for 1 second, so hold on.
Hey, Mike. From attorney, you drop it off.
All right, Ms. Van Duzen.
Robert.
All right, so this is in the matter of the people of the state of Michigan versus Milton Trey Rembert. We have two files, 22-21191FH and 22-21090FH. Now, it is a probation violation of sentencing on 22-21090, and it is about sentencing on the other as well. I did receive a pre-sentence report that I showed was emailed to you on February 21st. Ms. Van Duzen, did you receive that?
I did, Your Honor, and I read it to the client.
All right, and Mr. Coast has popped on, so let me see. He is here for, Mr. Coast, are you here on Rembert?
I am, Judge. It's on a motion and order show cause file 21191
All
for
right,
missing drug
and
screen.
Yep, so Mr. Rembert also missed a drug screen on that file as well, so we have that contempt of court. So Ms. Van Duzen, are you ready to proceed today?
Yes, Your Honor. Well, I don't have the missing the drug screen on him. I have a contempt of court for failing to appear in front of your court.
Okay, and when was the drug screen missed, Mr. Coast?
Judge, was missed on 111 of 23, 114 of 23, and then after the show cause was created, he missed 5 additional drug screens
Okay,
in January and also
point,
February.
Yep, and we took him into custody at that point. Is that correct?
Uh,
Well, he's in custody.
correct. Yeah, I believe we got a warrant for him for that.
Okay. All right. So Ms. Van Dusen, those are back in January in the file. Do you at this point want to proceed with sentencing, and what would you want to do with the contempt of courts?
The contempt of courts, he should plead guilty to and proceed with sentencing.
Okay, all right. So, Mr. Rembert, do you understand there was a motion affidavit and bench warrant for failure to comply with drug testing?
Yeah.
And that's on file number 22-21191 FH. Do you understand that?
Yeah.
And the allegations on the one filed January 18th of 2023 were that you failed to test on January 11th of 2023 and January 14th of 2023. Do you understand that?
Yeah.
Do you understand the maximum penalty for contempt of court can be up to 93 days in jail?
Yeah.
Okay, all right. So Ms. Van Dusen, why don't we sentence him on the probation violation first? Is that all right?
Yes, Your Honor.
All right, so. Double check something. All right, so Mr. Rembert, have you had a chance to review the probation violation report with Ms. Van Dusen?
Yeah.
Are you satisfied with Ms. Van Dusen as your attorney and the
Yeah.
advice that she has given you? Yes,
Yeah.
okay. Ms. Van Dusen, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
No, Your Honor.
All right, before the court passes sentence on the two files. Oh wait, that's 9-0. Let's see. Not 1 and 9-0. Did you get a probation violation report for 9-1?
Judge, 9-1 is he's not pled on.
Okay, so that's still a new file.
Yeah.
Okay, I'm sorry. I think because their numbers are almost the same, I thought they were both being sentenced today. All right. Okay, control and show cause. All right, so it looks like Ms. Van Dusen on file number 22-21191 FH. We have a motion affidavit and bench warrant for failure to appear for pretrial and show cause that he has not pled to. And then we also have the contempt of court for failing to screen. So, and then on that underlying file, there's no plea been entered. Does that sound right with your notes, Ms. Van Dusen?
Yes, it does, Your Honor.
Okay, so in light of that, do you wish to hold off on the violation of probation sentence and proceed with this file? Like, he's going to plead to the contempt of court, you said, but what about the underlying file?
The underlying file we're going to set over. He has a new felony coming forth.
He does?
Yes.
Okay. Do you want me just to set it all over?
Can we do that, Your Honor?
How far do you want the pretrial set over?
His exam would be on the 3rd, so 2 weeks after that.
March 3rd. Right, so March 15th.
That looks
That
good,
fair?
Your Honor. Yep.
All right, so Mr. Rembert, here's what I'm gonna do, because you have some new charges. I'm gonna set all of this over to March 15th, okay?
For sentencing too?
I'm sorry?
For
For the
sentencing too?
sentencing. Yes, so I'm gonna set it all over, and I'm gonna enter a plea of not guilty on the failure to show up or failure to appear. That way we can verify whether or not they're charging me with absconding. So Mr. Rembert, I'll continue your not guilty pleas, and then we'll have you back on both these files and potentially your new one if it gets bound over for a pretrial on March 15th at 8:30. All right?
All right.
All right. Thank you, Mr. Rembert.
All right.
Thank you. All right. Thank you, Ms. Van Dusen. All right. Who do I have joining me from the jail, please?
Mr. Roberts.
Yeah.
All right, Mr. Roberts. Hold on. Just real quick.
You ready for the
Roberts.
Kelly?
Oh my gosh. All right. All right, Mr. Roberts, who is your attorney?
Milaro.
Mr. Milaro. All right, this is in the matter of the people of the state of Michigan versus Kyle Lee Roberts at file number 23-21233 FH, 23-21234 FH, 23-21235 FH, 21-20383 FH, 21-20678 FH, 19-19684 FH, 19-19685 FH, 19-19686 FH, and 21-20215 FH. So, Mr. Milaro represents Mr. Roberts, and I have Isaac Sneed appearing on behalf of the people. Pause there for a minute. Now I have another gentleman that just joined me from the jail wearing glasses. What is your name?
Richard Kelly, ma'am.
What's your last name?
Kelly.
Kelly. And
Yeah,
that
this
is
John
a
Murphy. That's
Mr.
one of my
Murphy.
clients.
Right. Do you need a breakout room, Mr. Murphy?
Please, Your Honor.
All right. So Mr. Kelly.
Oh, yes, ma'am. I got it. Thank you.
Yep. Hold on. I'm gonna open up a breakout room for you, Mr. Murphy. So,
They're getting it.
hold on, Mr. Kelly. There.
Break it home.
All right, go ahead and join that breakout room. All right, so Mr. Milaro, on behalf of Mr. Roberts, how do you wish to proceed today?
Your Honor, I haven't had time to get over to the jail to talk to Mr. Roberts, so I'm going to ask to adjourn these out one time for a brief period so I can get over there.
Right, my next available pretrial is April 12th at 8:15 in the morning, or 8:30 in the morning. Is that good?
Yep, perfect, Judge.
All right, so Mr. Roberts, I'm gonna set all of these over for a pretrial on April 12th at 8:30 in the morning. And we'll see you back on that day. All right, Mr. Roberts?
All right, thank you.
Thank you.
Judge.
All right, let's see, another jail window. I'm gonna walk all of Mr. Roberts' files with Miss Adams real quick.
Old paper's not on the screen, so.
Hi, who do I have from the jail? Yep, you. What is your name, please?
Tyrone Lewis.
All right, Mr. Lewis, hold on a second. And change your screen name. Who's your attorney?
Mr. Malero.
All right. Mr. Malero, do you need a breakout room with Mr. Lewis?
I do, Your Honor.
All right, so, close all these rooms. Right. So Mr. Malaro, I'm going to put you and Mr. Lewis in a breakout room. Go ahead and click on join. All right, so Mr. Murphy,
Yes, Your Honor, and my connection has not been stable this morning, so I've been proceeding without my video, if that's okay with you. It seems to keep my connection okay.
that's fine.
I'll
All
try
right,
to talk really
this is in
fast.
the matter of the people of the state of Michigan versus Richard Eric Kelly. I have 3 files, 23-21210FH, 23-21211FH, and 23-21212FH. I have Matthew Murphy appearing on behalf of Mr. Kelly, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Murphy, how do you wish to proceed this morning on behalf of Mr. Kelly?
Yes, Your Honor, I just, I wanted to place on the record the offer at this time. From my understanding, Mr. Sneed was offering for Mr. Kelly to plead as charged in the file ending 1-2FH would be the retail fraud first degree. And the file ending in 1-1FH, it would be to an attempted resisting opposing an officer, dismissing the fleeing and eluding third degree in that case. And file ending in 10-0FH, it will be to a use of cocaine, dismiss the possession of cocaine, second offense. And at this time, I have expressed that to Mr. Kelly. I just wanted to make sure I put it on the record. The audio was a little bit off in the breakout session, so I wasn't sure. I believe he heard the offer and he understands it. At this time, I believe what we want to do is ask to set a jury trial on this matter, and then would ask if the court be willing to address bond.
Okay, so Mr. Kelly, he was concerned about the auto, so I'm going to go through the files. On 23-21210FH, you're charged with possession of cocaine less than 25 grams, but you do have a drug supplement, which makes that a maximum penalty of 8 years in prison. But you also have a habitual offender fourth offense notice. So that actually makes it a 15-year felony if you're convicted on that file. Do you understand that?
Yes,
Okay, and the plea offer on that file was to plead to, is that count 1 a 4-year possession, Mr. Sneed?
That would
No, actually, we were offering a use of cocaine,
be
a 1-year misdemeanor.
So that would be, the plea offer was to a use of cocaine on that file, which is a 1-year misdemeanor, okay. And then on file number 23-21211FH, you are charged with police officer fleeing third degree, which is a 5-year felony, but you actually have a habitual offender fourth offense notice. So if you were convicted on that file, you'd be looking at a life in prison. Do you understand that?
yep, yes,
Okay, because you have a habitual offender fourth offense notice, and because it's a 5-year felony, a conviction on that file would be life in prison. Do you understand that?
yep, yes,
Okay. And then on file number 23-21212FH, Mr. Kelly, you're charged with retail fraud first degree, which is also a 5-year felony, but you also have a habitual offender fourth offense notice. So you would also be looking at life in prison on that file as well. Do you understand that?
yes,
If you were convicted at trial. So the plea offer on that file, let me see, is plead as charged to just the 5-year with no supplement. So all in all, you're probably looking at probation and maybe county jail on these files. Do you understand that if you took the plea?
okay, talk to Mr. Murphy again real quick. I'm just,
No, let me put you in a breakout room with
because,
Mr. Murphy.
ma'am, the reason I'm doing this is because.
Hold on,
don't say anything on the record, Mr. Kelly. That's fine. I can convey it to the judge if you want me to.
Say it again, Mr. Murphy.
I was asking not to say anything on the record. If he wants me to tell something to you, I will afterwards, but I want to.
Right. So here's what I'm gonna do, Mr. Kelly. I'm gonna put you and Mr. Murphy back into a breakout room and have a conversation, and then go ahead and join that breakout room. All right, hi to the jail. What is your name, please?
Cody Bradley.
All right, Mr. Bradley, I'm going to type in your name and who's your attorney?
Sal Millar, I believe.
All right, so change your name, and when Mr. Millar is done talking to his current client, we will take your case.
Doing okay sitting in here?
Thank you.
Slide that chair.
All right, Mr. Kelly, let's get Mr. Murphy, and Mr. Kelly. Are you ready? Yes, Mr. Murphy.
I was wondering if the court would be willing to engage in maybe a quick Cobb's conference in regard to this case. If
Not
Mr.
right now, no. I can bring him back. I mean, if you talk with the prosecutor. I can't, Mr. Murphy. I've got the jail backed up. I just can't right now. I can.
Well, I guess I'll just ask on the record if Mr. Kelly was to
Mr.
take the
Murphy,
offer. Oh,
Mr. Murphy, we're kind of got a lag. I can do it at a later time today, but not right this moment.
okay. Could we come back later today?
Or I can do it tomorrow morning.
Okay, I mean, Mr. Kelly's wanting to try to get released as soon as possible if he was to take the plea. So if we could do it later today, I'll talk with the court and see if we want to do it then.
Tomorrow's fine too, man.
Whatever, either tomorrow, Your Honor, whatever fit the court's schedule best.
So Miss Adams, can I put this in at 8 o'clock tomorrow morning?
You have.
Yeah, I know.
6 sentencings and drug courts.
Yeah, okay. We'll put it for tomorrow morning at 8 o'clock. But Mr. Murphy, you got to be here right at 8 o'clock.
It'll be the first thing on my schedule. I'll be there.
Okay, so, all right, Mr. Kelly, we'll see you back here tomorrow morning at
Yes,
8
ma'am.
AM, all right?
Yes, ma'am.
Thank you, Your
All
Honor.
right, thank you.
All right, Matt. Thanks, Matt.
And that means the prosecutor needs to be here too. Who's my prosecutor on that one?
It's Mr. Sneed. Sorry, Mr. Sneed.
You too, Mr. Sneed. I'll see you at 8 o'clock tomorrow morning. All right, so I have Mr. Lewis and Mr. Malawi, you represent Mr. Lewis?
I do, Your Honor.
All right, this is the date and time set for arraignment on file number 23-21266FH. Mr. Malaro represents Mr. Lewis, and I have prosecutor, somebody turn their picture on, Mr. Sneed appearing on behalf of the people. Mr. Malaro, do you waive the reading of the felony information?
Your Honor, we acknowledge or see the information, waive its reading in open court, waive any defects at the time of service. And at this time, Mr. Lewis would be entering a plea of guilty to aggravated stalking.
Right.
I'm sorry, attempted aggravated stalking is pursuant to our discussions in district court.
All right, so Mr. Sneed, the plea offer is to an added count 2 aggravated stalking, which is a 2.5-year felony.
Yes.
Yes, Your Honor.
Okay, all right, and Mr. Sneed, you'll get me an amended information today.
I will, Judge. Thanks.
Thank you. All right, Mr. Lewis, do you waive the reading of the felony information, Mr. Malone?
Yes, we would.
All right, Mr. Lewis, now you can raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record, Mr. Lewis?
Tyrone Edward Anthony Lewis.
All right, so Mr. Lewis, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to count 2, attempted aggravated stalking, which carries a maximum penalty of up to 2.5 years in prison?
Yes, ma'am. Yes, Your Honor.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
And Mr. Sneed?
Yes, that is, Your Honor.
And Mr. Lewis, is that correct as far as you're aware?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. Mr. Lewis, how do you wish to plead to the charge that on or about January 25th of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense of attempted stalking aggravated? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
All right, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro
No, Your Honor.
and Mr. Sneed.
No, Your Honor.
All right, Mr. Lewis, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Okay. Is it your own choice to plead guilty?
Yes, yes, it is, Your Honor.
All right. So, Mr. Lewis, on or about January 25th, 2022, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right, and did an individual with the initials LW have a personal protection order against you?
Yes, Your Honor.
Okay, and were you served with a copy of that personal protection order?
I was, Your Honor.
And so you knew it was in place, is that correct?
Yes, Your Honor.
All right, and so after you received notice of that, did you in some way have contact with her, either in person, delivering something to her house, texting her, having people text her? What did you do?
I was at the victim's house and I was knocking on the window of their front door.
Okay, now would you agree that because they had a personal protection order against you already, that behavior could have caused that person to be frightened or intimidated or threatened?
Yes, Your Honor.
Okay, Mr. Sneed, are you satisfied?
Yes, Your Honor. Thank you.
All right, has court complied with MCR 6.302 B, C, and D? Mr. Malaro,
Yes, it is, Your Honor.
Mr. Sneed?
Yes, it has, Your Honor. Thank you.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation, and we'll set sentencing for April 14 of 2023 at 8:15 in the morning. Mr. Malaro?
Yes, Judge, could we address bond real quick? Not, it won't take.
Sure.
So Mr. Lewis has a pending misdemeanor downstairs that may or may not get resolved along with this. My notes say that he was granted a GPS bond. The bond in this case, I believe, is $3,000 cash or surety. Mr. Lewis is employed at Chick-fil-A up in, is it Livonia, Mr. Lewis?
Yes.
So he has a job. It is true that on the underlying cases, he kind of, got mixed up and didn't show up for court, but I've read him the Riot Act. I've explained to him how important it is to show up in this court on time, and depending on the court's position on certain matters, the court could, all appearances. And so we would ask the court to consider mirroring the district court order and allow him a GPS tether. For
All right, Mr. Sneed?
Your Honor, I would defer to the discretion of the court pending sentencing.
All right, Mr. Coast, would you speak to him on this regarding GPS, or would that be through district court now?
Yeah, I could speak to him, Judge.
Okay, because I think, all right, so Mr. Lewis, I will release you on a care bond with a GPS tether. So they usually put that on you before he leaves the jail. Is that correct, Mr. Coast?
It is, Judge.
All right, so Mr. Lewis, I'm going to need you to appear in person for sentencing though, okay?
Yes, Your Honor.
And you're working at Chick-fil-A?
Yes, Your Honor.
Well, I don't want to get in the way of God's chicken. So, Mr. Lewis, so if you cut or disconnect your tether if you do not show up for sentencing, you will be in so much trouble. Do you understand that?
Yes, Your Honor.
All right, so sentencing will be April 14th of 2023 in person. That'll be at 8:15 in the morning. Your paperwork from the jail will have that date on it. I'm going to put you in a breakout room with Mr. Coast and Mr. Moore, because Mr. Coast will give you instructions about the tether and Mr. Moore will give you instructions from the Michigan Department of Corrections. They're gonna give you instructions how to meet with them, how to contact them. Make sure you attend your pre-sentence interview with Michigan Department of Corrections and fill out your packet. And then make sure you show up for sentencing. When you meet with the MDOC for your screening, make sure you're truthful about your background, the events that occurred. They'll prepare a report. That report will be provided to your attorney. Get a hold of Mr. Malaro before, like the week before sentencing, so that you and he can go over that pre-sentence report. And then we'll see you back for sentencing on that day. All right?
Yes, Your Honor. Thank you.
You're welcome. So I'm going to assign Mr. Lewis, Mr. Moore, and Mr. Coast to a breakout. Go ahead and click on join.
Thank you, Judge.
Thank you. So, Mr. Bradley, right? Yeah.
Yes, ma'am.
Hold on. Who is your attorney, Mr. Bradley? Mr. Malaro?
Yes, ma'am.
All right, Mr. Malaro, the matter of the people of the state of Michigan versus Cody Joe Bradley, file number 22-21174FH. Mr. Malaro, how do you, I have Alexander Bayonetto appearing on behalf of the people. Mr. Malaro, how do you wish to proceed today?
Yeah, Mr. Bradley, do you want to plead to retail fraud second, a 1-year misdemeanor?
Not sure. Could I break out with Mr. Malaro?
Of course. So, Mr. Malaro, I am going to assign Mr. Bradley and yourself to that breakout room.
Thank you, Judge.
Go ahead and join the breakout room. I'm gonna take these files.
Hey, you got me? I gotta write down some numbers. Write down some numbers. You got paper? I got paper.
All right, Mr. Malaro, let's see, you were in with Mr. Bradley. I'm gonna close all the breakout rooms and bring them back. All right, Mr. Lewis, you all set?
I believe so.
All right, thank you. Have a good day.
Thank you.
All right, Mr. Malaro, back with Mr. Bradley. How do you wish to proceed with Mr. Bradley?
We're gonna ask to set this for another pretrial in the matter. Mr. Bradley informed me as a parole hold, and I'll have to look into that.
All right, where are you on parole, Mr. Bradley?
Right here in Lenawee, ma'am.
All right, Mr. Moore, what is your question about your parole hold?
Your Honor, I was just in another accident. They're aware of it. I'm only in jail because of missing court while in the hospital, as well as the hospital cutting my tether off. I just want to know why I'm on parole hold when I was kind of supposed to be on a medical leave. I guess I just need my officer to come speak to me.
Who's your parole officer?
Hey, Face. I've been in contact with Mr. Moore and everybody. They know what's going on, I believe.
Okay, all right, well, I can set this out. My next available pretrial is April 5 at 8:30 in the morning. Mr. Malaro, if you're able to resolve it, you can bring it back before that
Yeah, Judge,
on another day other than a Wednesday.
I don't show what court date he would have missed, so I don't know. Not anything I have with him, but that's, I'll look into it.
Well,
I had a missed court date and the tether and something else. I don't know. It's all been. I went to court on it yesterday. It's taken care of. I'm just here on the holder now.
Oh, that was a different case in district court you're talking about?
Could be.
All
I'm
right.
not sure. I don't believe so.
Okay, we have him listed as an absconder. Who arrested you?
APD. I was literally across the street from the courthouse. I was supposed
He
to come
just
see you
asked
guys
a
today.
question. It was APD's your answer. So APD arrested him, Mr. Moore. So he's on absconder status from MDOC, Mr. Malaro.
Oh, okay, but he said he missed a court date and I don't show anything, so.
I think that's downstairs. He just said maybe. He must have a misdemeanor. I don't know.
If he does, then we're not representing.
I'm not sure either.
His parole officer will be coming to see him.
Okay, so my next available
Thank
date
you.
is April 5th at 8:30 in the morning. Mr. Malaro, if you can resolve it, you want to bring him in sooner.
Absolutely.
Go ahead and contact Ms. Adams and we'll do it on a day that's not a Wednesday, all right?
Yes, Judge, I will most certainly try to do that.
All right, thank you, Mr. Bradley.
Thank you. Have a good day.
Thank you,
Thank
Judge.
you. Thank you. And you'll do the stiffen order to adjourn with permission from the prosecutor's office, I'm assuming. All right.
Yeah, yes, Judge.
So that takes care of Mr. Bradley. So now we need Mr. Anderson, Mr. Holbrook, and Mr. Lau. And Mr. Murphy,
Yes, Your Honor.
we do have some positive drug screens on Mr. Lau. All right. Do you want that information? I got a letter from Mr. Coast regarding Mr. Lau.
Was that sent to the office already? That
No,
paperwork?
it was just sent to me, but Mr. Coast, are you able to email that, or do you want me to have Ms. Adams send a copy to Mr. Murphy?
Judge, I could send a copy over to the public defender's office.
Okay, thank you.
Your Honor, may I ask a quick question? Which
Sure.
cases do you still have to go?
I have Anderson, Girth, Holbrook, Lowe.
Okay, Holbrook, we filed the Nolly. She passed away.
Oh, wait, I already called that. Yep, she did.
Okay, so
All right, so
thank you.
Anderson, Girth, and Lowe.
Thank you.
All right, sorry about that. Oh, no, I'm sorry.
Judge, Mr. Muad had emailed that he mailed in waivers for girth, just a heads up.
All right, that's right. So in the matter of the people of the state of Michigan versus Zachary Kyle Girth, file number 23-21268 FH and 23-21269 FH. There is a waiver by mail on those. All right, so that leaves us with Lau and Anderson. All right. So, let's see. Hi, this is Judge Anselone. So we still need Caleb Anderson and Dennis Lau.
Anderson and Lau.
I've got like 3 windows open, so I don't know that I need all those, but if I could get both of them like at the same time, that'd be great.
It'll happen in just a couple minutes.
Thank you.
You're welcome.
Bye. Work from home this afternoon. Okay. You can do that, unless I don't work from home. No. Sounds more excited than what we're doing.
I hope it doesn't translate to the truth.
That's funny. That's so funny. So when we're done, then just Google work from home.
Okay, we don't have anything second.
No.
Yeah, I was just a little nervous because, you know, I was like, I think I didn't get nervous driving anymore.
I know, but you know we do people in person on Wednesday, so I don't know why you would ask that.
Well, if it's icy, I can always hear it at the podium.
Yeah, yeah, I understand.
So you.
I'm live on YouTube.
You didn't hear that.
Becky, if there's paperwork you need me to sign, you want to bring it to me, I'll sign it.
All right.
I'll touch someone. She come up in about 15. All right, Mr. Lau, who did you say your attorney was last time? Mr. Murphy, right?
Yes, Your Honor.
All right, Mr. Murphy, do you need a breakout room?
Please, Your Honor.
Great. So hold on. Let me add some more breakout rooms. So, here, Lau, let me change your screen name. So I'm gonna put Mr. Lau and Mr. Murphy into a breakout room. Go ahead and join that breakout room. Use the mouse.
Okay.
Yep, go ahead and join that.
Yeah. How you doing? Right. Yeah. Right. I had a description, I gave it to him. And he said that I could,
Actually, you're talking to Matt, the next judge.
Hi. I got a job. What's that? With me having a job, too, would that make a difference? What do you think? Yeah. When I went to court the last time, I think you were the, if you have a new house, you on it. That was more, already out of the system when I went back to court the last time. Yeah, yeah. Okay. All right, thank you. You guys learn how to have a job, please?
Your Honor, for Mr. Lau, are we here on contempt bond violations? We're not here on the underlying charges, correct? Those were set for trial.
I didn't know you were back, Mr. Murphy. I'm sorry.
I just got back. Sorry.
Okay, I'm sorry. Let's see, Mr. Lau, I have. I'll bring him back. Where's he at?
Judge, I believe it's
have
just the contempt.
Just the contempt,
I
Mr. Murphy.
believe so.
All right, thank you.
All right, so, in the matter of the people of the state of Michigan versus Dennis William Lau, 22-20837, 22-20836, Mr. Murphy, on file number 22-20836 FH, we are set today for arraignment on a bench warrant. Public Defender's Office was appointed. The contempt court is for testing positive for buprenorphine, morphine, and fentanyl from a screen collected on June 24th of 22. And then also positive for amphetamines on a screen collected December 20th of 2022. And it returned positive after being tested for methamphetamine and amphetamine. And then on file number 22-20837 FH or the contempt of court bench warrant arraignment for same thing. Same thing. I also had a letter somewhere here. There we go. From Mr. Coast stating that Mr. Lau tested positive for amphetamines and meth from a drug screen collected December 20th of 22. He started taking Adderall prior to the test without getting permission first. We sent the sample to the lab. It returned positive for meth and amphetamines. I told Mr. Lau not to take the Adderall because of the nature of his case, and to consult his physician to get on a different medication that would make the drug screen positive. He was aware of the warrant, but refused to turn himself in. He continued to test, and the majority of his tests returned positive for amphetamines, Suboxone, and fentanyl. He was arrested on the warrant when he reported to drop this past weekend. And so, yeah. That's where we're at, Mr. Murphy. So, Mr. Lau, you were arraigned on these already and appointed, and obviously Mr. Murphy represents you. So the maximum penalty for contempt of court could be up to 93 days in jail and a $7,500 fine. So, Mr. Murphy, how do you wish to proceed with Mr. Lau?
Your Honor, at this time, from my understanding, Mr. Lau wants to accept responsibility and plead guilty to the contempts. They stem back from June and then, December of this year. Obviously, the court can see the situation. So obviously, we just want to plead guilty to the contempts and then continue along on the underlying case. I believe that one is scheduled for May 24th.
For trial?
Yes. I mean, obviously, I'd ask for, well, I guess in regards to the contempts, we'll take the plea. I'd ask to consider sentencing today for those.
Okay. Okay. All right. So, Mr. Lau, raise your right hand, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
So you put your hand down. So, Mr. Lau, you understand the charges and the allegations I just read to you regarding contempt of courts?
Yes, Your Honor.
Do you understand the maximum penalty if you plead guilty to a contempt of court can be up to 93 days in jail or up to a $7,500 fine?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice that he has given you?
Yes.
All right. Now, do you understand that you have a right to contest these contempt of court charges and to have a trial on them? Do you understand that?
Yes, Your Honor.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at the trial if you want to testify?
Yes, Your Honor.
All right, so we have 2 contempt of court. So on the contempt of court, signed by me on June 27th of 2022, how do you plead to the charge that you violated the bond conditions by testing positive for Suboxone, morphine, and fentanyl on June 24th of 2022? Guilty or not guilty?
Guilty.
Okay, and that is on both files, correct? Yes.
Yes.
All right, and then on the second contempt of court was signed by me on January 25th of 2023. So how do you plead to the charge that you tested positive for amphetamines on a screen collected December 20th of 2022? Guilty or not guilty?
Guilty.
Okay, and that would apply to both files. Has anything been promised you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
All right, so Mr. Lowe, you are currently on bond now on file number 22-20836FH for delivery, manufacture of methamphetamine, delivery, manufacture of cocaine, receiving, concealing 3 counts, controlled substance possession of methadone, delivery of methamphetamine, another one, a felony firearm. And then on file number 22-20837, you're on bond for delivery, manufacture of methamphetamine, heroin. Oh, no, that's cocaine. Police officer, a couple counts of police officer R&O. And one of the terms of your probation that allowed you not to be in custody was that you were not to use any illegal controlled substances. Would you agree with that?
Yes, Your Honor.
Okay. Now you reported for a drug test back on June 24th of 2022. Is that correct?
Yes.
And at that time, you tested positive for buprenorphine, which is Suboxone, I believe, morphine and fentanyl. Is that correct?
Yeah. I had a prescription for the for the
Right.
Suboxone.
But you didn't have a prescription for morphine and fentanyl. Is that correct?
Right, but I was getting false positives. I've been getting coming up for fentanyl for the last year because of boost bars, and this is the first time that I've heard anything about being positive for the fentanyl. I'm on Suboxone, so it wouldn't even make sense for me to use fentanyl because Suboxone's a blocker.
Okay, so I can't accept that plea then. So, Mr. Murphy, I can set this for a trial on the contempt of court. Mr. Murphy, so, Ms. Adams, I need about 40 minutes or 30 minutes or 40 minutes for a contempt trial, whenever the next date is available.
Okay.
Mr. Lau, you said you had a prescription for the.
Mr. Murphy,
Yeah.
I'm gonna set it for a hearing.
Judge, it looks like we could do March 10th at 2:30.
All right, so I will set this for a hearing on March 10th at 2:30. Mr. Coast will need to be present. Are you available that day, Mr. Coast? You said March 10th at 2:30. Yep.
Judge, I'm available that date and time. And what I'll do is I'll prepare a packet for the prosecutor and also for Mr. Gonzalez.
All right, Mr. Sneed, would you be my prosecutor that day? Somebody will. All right, so we'll see you back on March 10th at 2:30, Mr. Lau. Thank you.
Your Honor, just
Thank
for
you,
the
Judge.
court's record, I think it's Miss Meir is on the underline in case you want to notify her about the contempt.
We just send a general notice to the prosecutor and they send somebody.
Sorry
Judge-
about the judge, I was on a call.
It's okay.
Judge, will we
All
need
right.
to be here in person for that, or are we doing that on Zoom?
Yep, we can bring him in person. All right. Thank you, Mr. Lau. You're all set.
All right, so I'm still in here till what, March 10th?
Yes, sir.
Yes, I'll come visit you or Zoom with you, Mr. Lau, okay, as soon as I can.
All right.
Thank you, Your Honor.
Thank
Have a good
you. You too. All right, so now
Your
we
Honor.
just need Mr. Anderson.
Your Honor, I'm sorry, I had down Jonathan Schoonover. Did Ms. Van Duzen handle that case?
Yes,
Okay, all right, thank you. Have a good day.
thank you. Miss Adams, and let me know when my individual gets up here for the meeting.
Okay.
Hey, Judge.
Hey,
Hey, if you have notes on your docket, there's a couple cases that I had missed when I was
sure.
watching on Zoom, and I don't know who covered them from our office, but it was a Christine Kramer, Cramer. I think it might have been
Yeah.
a plea.
Let me find her. She is set for, oh, I took her into custody. I just need Mr. Anderson from the jail. That's the only one I have left. No. All right, so she tested positive for methamphetamine. So I revoked her bond and set it at 50,000 cash surety and took her into custody and set it for March 8th at 8:30.
Okay. And then Schoonover, was that adjourned?
Schoonover pled guilty to attempted R&O, which is count 3 that has to be amended, I think.
Okay.
And with a plea agreement that if he qualifies, he would get HIDA. And I set it for sentencing on April 14th at 8:15 in person.
Great. And then lastly, Judge, thank you for doing this. Zachary McFarland, PPO.
Yes, so he entered a plea of not guilty, but there was, they needed another meeting about something. So it was set for pretrial on April 12th at 8:30 in the morning.
Thank you very much.
All right, thank you. All right, Mr. Anderson?
Yes, ma'am.
All right, Mr. Malaro, do you represent Mr. Anderson? All
I do,
right.
Your Honor.
This is in the matter of the people of the state of Michigan versus Caleb Michael John Anderson. We have 3 files, 23-21247 FH, 22-21127 FH, and 22-21106 FH. This is the date and time set for a pretrial in this matter. Mr. Malaro, how do you wish to proceed today?
Yeah, I'm going to ask to adjourn this out. I did not have a chance to get over to see Mr. Anderson before today, although that was one of the things I was trying to get done. But I will go talk to him. If we get this worked out, I will let you know and we'll bring him in sooner.
Okay, so Mr. Anderson, There's had some difficulty getting in to meet with people lately. As you can tell, you know, it's 12:51 and I just got you. So what I'm gonna do, so listen to me, Mr. Malaro is gonna come meet with you as soon as he can get in. I'm gonna give you a pre-trial date, okay? But if there's a resolution, Mr. Malaro will get you in right away. Do you understand that?
Yeah.
Okay, so my next available pre-trial date is not till April 12 at 8:30. But as I said, if Mr. Malaro and you reach some resolution, he'll just call me and I'll bring you in any day of the week, okay?
Okay.
All right, so.
Is there a certain day? Is just whenever he can get over to me?
Yeah, Mr. Anderson, had some things come up last week that kind of messed up my schedule. That were beyond my control, but I'll try to get over there tomorrow.
Okay, all right. I was just wondering, because I'm supposed to be out on my other charges on next month on the 15th. I don't want that being messed up again, because I was supposed to be out on the 18th this month, and then.
Okay,
Yeah.
all right,
So,
so he's gonna get over this week to see you, so thank you, Mr. Anderson.
All right, thank you.
Thank
All
you.
right, thank you all, and that concludes our criminal docket.
I'll do the step in order, Judge,
Yes, sir, thank you.
assuming Mr. Sneed has no objection.
No,
He
thank
does
you.
not.
Or Mr. Moore.
Bye, Judge.
Bye, everybody.